So hello everyone and welcome in part 12th of the Bear Act series, and in this video we will discuss from article number 71 to article number 75 clause by clause and article by article. So let us start from article number 71. Article number 71 provides some facts or the important information regarding the election of the president and vice president, and this article contains four clauses. Okay, now clause 1 is relating to the election disputes of the president or the vice president, or any doubts that are related to the election of the president and vice president. Now this case is decided by the Supreme Court, and the decision of the Supreme Court will be final. That means the final authority to decide such election cases of the president and vice president lies with the Supreme Court. In the case of MLA and in the case of MP, this power lies with the High Court of the state. Okay, but as you all know, vice president or president does not belong from the any house or from the any state, so the final authority lies with the Supreme Court. Now suppose if someone challenges the election of the president or the vice president, then Supreme Court will decide the matter. That is the 71 clause 1. Okay, now clause 2 is about that if Supreme Court declares the election of a person as a president or a vice president void, okay, acts done by that person before the date of Supreme Court decision are not invalid. That simple meaning that suppose a person was elected president and that person performed official duties for the several months. Later on, the Supreme Court cancels their election. Okay, now the official actions that are taken place before the court's decision do not automatically become invalid. That is the clause 2 of the article 71. Okay, so clause 3 is about that parliament may by law regulate any matter relating or connected with the election of president or vice president. That means parliament has the power to make a law that are completely related to the election of the president or vice president. That simple means that how the election will be held for the post or for the office of the president and vice president. So the power to make such law is vested in the parliament. So parliament can make law dealing with the procedure and other matter connected with presidential and vice presidential election. Okay, subject to provision of the constitution. Now clause 4 is about the election of a person as a president or vice president shall not be called in question merely ground on the existence of any vacancy in the electoral college. Let us make it simple for you. Let's suppose if some seats in the electoral college are vacant. Okay, that doesn't mean that elections are invalid or elections will become invalid. That means vacancy in electoral college does not automatically cancel the election. So 71 clause 1, 72 clause 2, 72 clause 3, 71 clause 3 and 71 clause 4. Okay, these are the articles that you should keep in mind. Now 71 was about that election disputes or any kind of doubts related to the election of president and vice president. The final authority is basically Supreme Court, and the decision of the Supreme Court will be final. 72 clause 2 was about that if a person elected as president or vice president, but after few days the election declared, that means void. Now the acts done before the decision of the Supreme Court, that acts will not be invalid. In article 71 clause 3 about that the parliament may by law regulate any matter that are related to the election of president and vice president. That means the lawmaking power relating to the election of president and vice president vested in the parliament. In article 71 clause 4 about that if there is a vacancy in the electoral college and if someone challenges that the electoral college was not full or there were vacancy in the electoral college when elections were held, now that does not automatically cancel the election. That is the simple basis of article number 71. Now article number 72 is giving the president the power to grant pardons. Now the clause 1 is about that president has the power to grant pardon, reprieve, respite and remission. That's apart from this suspension and commutation. So in the cases mentioned in this article, now let us understand it. Now the simple term here that where the punishment or sentence is the court of law. So basically these are the cases, are the types of cases, right? The president can pardon, reprieve, respite or remission, or even they can suspend the punishment also. So if there is a case related to the court martial, that power also lies with the president, but this power does not lie with the governor. Okay. Now, apart from this, let's suppose if a person is punished by a military court, that means court martial, then the president can exercise the pardoning power, but government can't. Sorry, governor can't. That means court martial can be pardoned, reprieve, remit by the president. Apart from this, second type of case, when where their punishment or sentence is for an offense against the law relating to a matter to which executive power of the union extend. That means, let's suppose if an offense that concern with the matters falling with the union's executive authority, now the president also in that case can exercise the pardoning power. That means even union executive matters comes under the president's pardoning power. So court martial one type, union executive matter second type. Apart from this, where this sentence is a sentence of death, as you all know, this is third type of case, where if a person is convicted, okay, and the trial court or any court, high court or supreme court, basically sentence him or her to death. In that case also president has the power to pardon, but in this case governor not. Governor can't pardon the death sentence, that you should keep in mind. So even death sentence can be pardoned by the president. Okay. Now clause 2, I was discussing 72 clause 1, and that clause has various types of cases, right? Now clause 2, nothing in the article 72 shall affect the power conferred by the law on the governor of a state to suspend, remit or commute a sentence of death. That simple meaning that article 72 does not take away governor's power under the law to suspend, remit or commute a death sentence. That means both constitutional office have relevant power, but their power are not identical in scope. That simple means governor can't pardon that sentence. One thing, governor can't pardon, remit or anything related to the court martial. Okay, but except these, all the pardoning power also lies with the governor. Okay, that is the simple meaning of the clause 2. Okay, so let's suppose that the case is basically related to the any officer of the armed force of the union, right? So governor has no power. Article 73, even death sentence also can't be pardoned by the governor, that you should keep in mind. Now article 73 is about the extent of the executive power of the union. So as you all know that executive power of the union is vested in the president. Okay, so the executive power of the union extend to the first matters with respect to which parliament has the power to make the law. Simple means that in the schedule 7 of the constitution, three type of the list are mentioned. The first list is about the central list, that means union list, state list and concurrent list. Union list, the items are the provisions that are contained in the union list. Parliament has the sole authority to make the law, and if there are some provision or the subject that are mentioned in state list, the authority to make the law under these provision lie with the state legislature, and there is a concurrent list as well. Under this list or the subjects that are included under this list, both parliament and legislature can make law. So the first is that let's suppose if there is a matter which are related to the union list, then parliament has the power to make the law. Okay, so where parliament has the power to make the law, the union executive generally has executive power over those matter. That means president also can make the law. Okay, as ordinance. Okay, when president will issue the ordinance in normal circumstances, that should be from the union list. Okay, so parliament's law making power is union executive power basically. Now the exercise of such rights, authority and jurisdiction are as exercisable by the government of India by virtue of any treaty or agreement. This is simple meaning that let's suppose if India gets certain rights or the power through an international treaty or agreement, then the union executive can exercise those power even in the state list. So if there is a subject that are included in the state list, that are included basically, and if that related to implement certain international treaty, right, then the parliament has the power to make the law even on the state list subject. That means treaty or agreement. Then also union executive can make the law. Simple meaning. Now, the Union executive power shall not, except as expressly provided in the Constitution or in any law made by Parliament, extend in any state to matter with respect to which the state legislature also has the power to make the law. That means concurrent list. Now, let's suppose if both Parliament and state legislature can make a law on the subject that are included in the concurrent list, then the Union executive does not automatically get executive power within the state over that subject. Okay, there must be a constitution or the parliamentary authorization. Clear? That simple means that parliament and state legislature both can make the law on the certain subject. Okay, if the subject is included in the concurrent list, then the executive does not automatically get executive power within the state. No, over that state subject. That is the simple meaning that parliament. That doesn't mean that parliament has the sole authority to make the law, right, over the state subject. Now there is a condition. If let's suppose a state makes a law under the concurrent list and parliament also make the law under the concurrent list, in this case parliament law will be prevail over the state law. That is the simple meaning. But under one circumstances, if the state law has the authorization or assent of the president, then state law will be applicable, not the parliament law. That is the simple meaning. Okay, until otherwise provided by the parliament, a state and its officers may continue to exercise certain executive powers that they were exercising immediately before the commencement of the constitution, even on the matters on which parliament has the lawmaking power. This is simple meaning that it is talking about continuity of the provision. It allows certain existing state executive power to continue until parliament make a different provision. That is the simple meaning of article number 73. This article was and is very important, and you should keep in mind whatever I have discussed. Okay, now article number 74 is about the council of minister to aid and advise president. Now from article 1 to article number 73, right, as you all already know that president power, but the power conferred on the president is basically executed by council of minister. That means president will do whatever the council of minister will tell them to do. That is the simple meaning. So there shall be a council of minister, and the council of minister will be headed by the prime minister, and this council of minister will aid and advise the president. Now according to the advice that are given by the council of minister, president will exercise his function. Okay, that means president does not normally take executive decision independently. No, the council of ministers that are headed by prime minister advise the president to take the decision or to do the certain function. Okay, that means there shall be a council of minister, and that council of minister will be headed by the prime minister, and prime minister and council of minister will advise the president, and president follow that advice. That is the simple meaning. Okay, apart from this, the president may require council of minister to reconsider its advice, either generally or otherwise. But after reconsideration, you should know 44th Constitutional Amendment Act, okay, 1978, that president may refer to council of minister to reconsider its advice, either generally or otherwise. But let's suppose after the reconsideration, the president must act according to advice standard. Okay, so president can say, please reconsider your advice, but the president gets this opportunity only to send it back for the reconsideration. And let's suppose council of minister does not make any changes, right, then president has to give the assent or to act on that advice. After the council gives that advice, president has to follow it. That is the simple meaning. Clause 2, the question, if any, and if so, what advice was tendered by the minister to the president shall not be inquired into any court. That means the advice that are tendered by the council of minister to the president, it shall not be inquired into any court. That means that advice could not be discussed in the court or can't be investigated by the court, whether ministers gave the advice to president or what exactly that advice was? No, courts can't investigate this. That means ministerial advice to president protected from the judicial inquiry. In the last article for today, article number 75, other provision as to minister. Okay, so the prime minister shall be appointed by whom? President, according to article 74. And the other minister will be appointed by the president, but with the recommendation of the prime minister. Okay, so the other minister shall be appointed by president on the advice of prime minister. So prime minister and other minister, they are appointed by the president, but prime minister will appointed by the president. And the majority party, basically the prime minister is from generally from the majority party who has secured the majority in the election. But let's suppose there is no party who secured the majority in the election, then it is the discretionary power of the president, and whom he or she thinks fit to form the government or to prove the majority on the floor of the house. President can basically ask that party or that candidate to took oath as a president. Okay, and other ministers are appointed by the president but recommended by the prime minister, because ultimately prime minister is the head of the council of minister. So prime minister appointed by president, other minister also appointed by president on the PM's advice. So the PM has the key role in selecting other ministers. Okay, and the total number of ministers including the prime minister shall not be exceed 15%, but it should also including the prime minister, that you should keep in mind because it is very important. Okay, and you also know it is added by amendment act. Okay, which amendment act? Could you tell me in the comment section as well? Okay, 91st. Okay, so 91st constitutional amendment act, this clause was added. Okay, that the total number of ministers shall not exceed 15%, even including the prime minister. So the council of minister can't be larger than the 15% of the Lok Sabha's membership. This include prime minister also. Clause 1b, a member of either house of parliament belonging to any political party who is disqualified under the paragraph 2 of the 10th schedule, that means disqualification under the 10th schedule, shall also be disqualified for appointment as a minister. That suppose if there is an MP or MLA, not MLA, if there is a MP who are disqualified under the 10th schedule, that particular MP disqualify for the appointment of as a minister, means he or she can't become minister for a period specified in this clause. That means this clause deals with the anti-defection law. If an MP disqualified under the anti-defection law, that is in provision of the 10th schedule, that person faces constitutional restriction because he or she can't become the minister. That means if anti-defection law you are disqualified, then it also restrict on ministerial appointment as well. Okay, apart from this, the minister shall hold office during the pleasure of the president. This is the most important and repetitive statement that asked by UPSC. So the ministers not on the pleasure of prime minister but hold office during the pleasure of the president. That is the important meaning. But if PM ask the president to remove the ministers, then president has to remove that minister particularly, but ministers remain in their office due to the pleasure of the president. Okay, so minister hold office during the pleasure of the president, but because India follows the parliamentary system, this operates within the constitutional framework of prime minister and the council of minister. Okay, now the council of ministers shall be collectively responsible to the house of people. It is also mentioned in the constitution, that means Lok Sabha. Okay, the entire council of ministers is responsible for Lok Sabha, not Raj Sabha or not parliament. Two words can be mentioned in the constitution, one is parliament and one is Raj Sabha. No, the council of ministers does not matter that ministers is belonging from which house, they were responsible to the Lok Sabha only. And if the government loses the confidence of the Lok Sabha, then the whole council of ministers is expected to resign. That is called collective responsibility towards the Lok Sabha. Okay, now before a minister enters upon his office, then the president shall administer him to the oath or office and mentioned in the 3rd schedule of the constitution. So every union minister must take 2 oaths. One is oath of office and second one is oath of secrecy, and both are mentioned in the constitution, oath of office and oath of secrecy. And the president administer these oaths. Who has the responsibility to administer these oaths? The president. Okay, so minister usually takes 2 type of oath that administered by president. One is office and second in one is secrecy. Okay, A minister who for any period of 6 consecutive months is not a member of either house of parliament shall be expired and cease to be member. Let's suppose if you are not an elected MP or nominated MP, then you can also become minister for the 6 month. But after that, if you did not become a member of the parliament, after 6 months you will be ceased to be a minister. But for 6 months, even anyone who is qualified to be a member of parliament, he or she can become a minister even. So if a person who is not an MP can also become a minister, but they must become a member of Lok Sabha Rajya Sabha within 6 consecutive months, otherwise they cease to be a member. Let us take a quick revision because the lecture is now becoming long. Article 71, election disputes, ultimate power Supreme Court, but in case of MP and MLA, the power lies with High Court. And the Article 72, President's pardoning power and also Governor, that I have explained to exception. Article 73, Union executive power. Article 74, Council of Ministers to aid and advise the Prime Minister. Aid and advise the President headed by Prime Minister. Article 75, Ministers, PM, they will collectively responsible to but House of People, that means Lok Sabha. Okay, so 71 election, 72 pardon, 73 executive power and 74 advice. I have covered almost every clause by sub clause even to make it very clear and clear. Okay, if you have any doubt, let me know in comment section. If you want that I should improve our fluency and or you are unable to understand my English language or explanation, then also let me know in comment section. I will try to make it more better for you. And if you like this video, kindly make sure you to subscribe this channel, like the video and ultimately share with your friends. So let's meet next video, part number 13 of the Bear Act.